So hello everyone, am I audible?
Yes, sir.
Okay, hi. So before we start, I just wanted to know how many of you are actually practicing. So all those of you who are practicing, please mention P in chat box so that I'll also have a fair idea, how to start this today's session. So Puneet ji has mentioned that he is practicing. Okay. Harvinder ji is also practicing. Then we have CS Prabhakar ji who is also practicing. Ashok sir is also practicing. So there are 4 people who are practicing. What about others? We see it's a very close compact group. So we need not to, keep it just a one-way interaction. It has to be dialogue between us. So I would request you all to please mention if you are practicing. Okay, so let us just proceed. So let me understand first of all, because we all have cleared this examination, so we are well versed what is this interim finance, whether we are practicing or not. So this interim finance, I won't go into the details at the very beginning. I would like to know it from you all, first of all, whosoever is practicing. What is the basic issue in this interim finance and how you people are handling that? May I hear it from Harvinder ji first of all?
Ma'am, in fact, in the cases where I am handling, we raised it through there was no interim finance, it was contributed by the stakeholders or committee of the creditors.
Okay. Okay. So how do you decide, sir, how much quantum we should take as an interim finance?
It was just an estimate, seeing the dimensions of the case, how much security cost is there, how much is the valuation, legal, what are all aspects, duties of the insolvency resolution professional. According to that, an estimate is made and that is placed before the COC. And based on that, an estimate is done, and with the covenant that later on, if still more contribution is required, the estimate will be put up before the committee of creditors.
Perfect, sir. Perfect. So may I have any other view also? Ashok sir has also mentioned. I think he's also practicing. Ashok sir, Mangesh sir, can we hear it from you whether you have faced any challenge in raising this interim finance? Mahinder sir, can we hear it from you first of all, and then I'll start? Why there is a need to discuss about this interim finance if it is such a simple topic? When everyone knows about it and it can be all resolved on its own. So why there is a need? There must be something challenging with respect to it. There must be some kind of confusion with respect to it. Can I hear it from someone? Vikasa, if you are there, can we hear it from you? Well, okay, that was very well portrayed by Harvinder sir. So I will take that clue and then I think we can proceed with that. So I'll just share my screen first of all. Just let me know if it is visible. Is my screen visible?
Yes, it is visible.
Okay, thank you so much, sir. I'll just make it full screen. So today's topic, as we all have gathered to discuss this raising interim finance. So basically, what is this term all about? That we will understand what are the legal provisions associated with it. Are there any challenges faced by resolution professional on this? So let us first see what all questions may come to your mind when you hear this topic. So the first and foremost question is, what is interim finance? So can anyone take a lead and answer that? I don't want an exact definition. It is just a simple version of ours. What do we think interim finance is? I request you all to please say something, because when you are investing time here, it is not just that you will I mean, there is nothing, no one is expert actually in this field, so it is just by discussion we will progress our knowledge. So this is the basic term, interim finance. We already know it is all about funds, and since the company has been short of funds, that is why it is going into liquidation, so or this insolvency process. So when a company is going into insolvency, that simply means that it is short of funds, right? So the starting process is when you file an application under any of the sections 7, 9, or 10. The background of this IBC says that the company should be taken up in a manner that it continues its process. It should be taken up as if it is a going concern, and we should try to resolve it as a going concern only. So we should first of all try for proper CIRP proceedings. But if we do not have any, this resolution applicant or a proper resolution plan we don't have, then we can proceed for the liquidation. So the basic crux of the insolvency itself says that the company, when it is short of funds, should be taken care by the resolution professional in such a manner that it continues to run on its own. So, but how the company will run on its own, because it is already short of funds. So, to continue its process, to undertake all the legal procedures or maybe its operating expenses, it requires some kind of funding. So that fund which we raise during the process of CIRP is simply known as interim finance. That is in very, very general layman language, as we can say. So interim would simply mean in between. So in between whatever funds you are raising, that is simply known as in between the process of CIRP, whatever funds you are raising, it is simply known as interim finance. We'll come to the legal definition also later on. But we are first of all discussing what are the general questions which come to our mind. So the next question which arises is it mandatory to raise this kind of finance? Can't we go without it? See, if there are funds sufficient enough to continue the process, but we are unable to, pay the big creditors or something like that, a big financial institution from whom we have taken the loans, even if we are unable to pay them, we can continue to run our day-to-day business. Then in that case we do not need uh, to raise this interim finance, maybe. But while in the process of continuing the CIRP proceedings, it might happen that at various point of time you may feel that though we did not apply for that interim finance at the beginning, later on you may feel that we need some funds. We need some more funds to pay off some professional charges, or to make public announcements, or to run business, to continue with the licenses and the other proceedings. So for that purpose, you can opt for this interim finance. Then again, a question arises: by what time you should, opt for this interim finance? Like, we have a timeline for each and everything. So as soon as the moratorium is established, or when CIRP is commenced, uh, then at that point itself you should raise the funds, or you can opt for it later also. What is your view? Can we have it later also, or we should analyze or calculate it at the beginning itself? Or is it open that we can have the interim finance at any point of time? and what are the legal steps to do to undertake all that. So as far as I can understand, the basic idea itself, it says that if you have initial funds, you can start with that, and sooner or later, whenever you realize that you are short of funds or you need some more funds to do the process in a very timely manner and in a very systematic manner, you can raise the interim finance at any point of time. It is just a matter of calculation it calculated beforehand, that would be better. And if you could not make out the sufficient estimate at the beginning, you can again raise this kind of finance. So there is no bar how many times you can opt for this interim finance. You can raise this interim finance as many number of times as you can, but it is always better to have it at one go, because again and again, a lot of legal formalities are involved, and it shows that you are not planned in a good manner if you are raising interim finance again and again. So it's better to have all the calculations done, how much funds will be required to normally get the operations on a going concern basis, and what all are the regular expenditure, that all you can make out, and a rough estimate could be provided for raising this interim finance. Then what are the legal provisions associated with it? We will come to it when I'll go to the next slides. So where in the code, where in the regulation, it is mentioned that you can have this interim finance. So actually, who's the responsible person? That is what we mean to say in this regard. Who's the responsible person to raise the interim finance and how it should be repaid? That is also one of the concerns which we must take care of. What is the use of interim finance? Again, a simple thing which we all understand, this whatever funds you are raising, it is for the regular operations of the corporate debtor, as well as to provide the legal formalities, to make the public announcement, to pay the professional fees, etc. So for all that matter, we need regular funding so that the business does not stop, and till the time we have a proper resolution plan, we should have the business continue in its very basic nature, so that we have a very good amount as business valuation. So for that purpose, we need to have proper funding. Then again, one of the question is, what is the source of interim finance? As Harvinder sir just mentioned, that it might not be that you have to raise funds from external parties or outsiders. It is just that the members of COC themselves contribute for raising this kind of interim finance. And if you are asking the COC to contribute for this interim finance, the basic thing is that it is divided in the proportion of the debt hold by them. So first you estimate the total overall requirement, and then you can allocate it according to the proportion of the debt hold by the COC members. That way you can raise. That is just one of the cases. But again, sources could be external also. So from some other banks or some other institutions or some other proposed investors, if they also potential investors, if they want to invest in this kind of business, you may seek help from them, and can ask them to provide this kind of interim finance. So this question is already answered. Is it shared between COC? Yes, in most of the cases it is shared between COC, and there's a case also related to that, where we can see that the COC, suppose if one of the members of COC denies that he doesn't want to participate, or it does not want to participate, then what will happen to that particular scenario? So that is also something which we need to understand, because this sometimes lead to arguments, and this might not come to a conclusion if put into COC. So is there any kind of established rule that it has to be divided or it has to be shared between COC? That is again a kind of question. Now, what are the benefits or disadvantages of raising this interim finance? As we already know, for the corporate debtor, The benefits is just that the company or the corporate debtor continues as a going concern, and it can, continue its functions till it has a proper resolution plan, or as the case may be. So that is the benefit for the corporate debtor. On the other hand, we should also analyze what are the benefits for the persons who are investing or who are providing the interim finance. So any one of you can tell me what is the benefit for someone who is providing interim finance? What is the benefit to him or her?
The only benefit is priority in payment, ma'am.
Right. Only thing is priority in payment, and that is a very big, I would say, big benefit which they are enjoying in this category, because the company, the corporate debtor, is itself insolvent. I mean, it is already undergoing this CIRP process. There would be a lot of haircut. Everyone knows that. So anyone who is providing finance is already under the fear whether we will get our funds back or not. So just to safeguard them, just to incentivize them, I would say this kind of benefit is provided in the code itself, that they will be given a priority in the payment. uh, Whenever there will be a payment, firstly they will be paid, and then later on rest of the amount will be paid to the other stakeholders. So that is the benefit which we can have. One more thing I would like to ask here: the interim finance, whether it comes with a cost, I mean, is there any interest also involved on that, interest charges?
Heavy cost.
Yes, it is heavy cost. So again, is there any benefit allied with that interest cost also, or only on the principal amount it is mentioned, or how is it? I'm asking whether the principal amount will be paid in priority, or the interest amount will be paid in priority, or both will be paid in priority.
Both will be paid in priority.
Of course, both will be paid. So sometimes there is a confusion that I mean, it may happen that we are not adding the interest amount while paying that off. So interest will also be calculated, and it will be added while paying the amount back. So what is the disadvantage then? We are seeing that this is a big advantage to the investors, but what is the disadvantage? Is there any disadvantage to the corporate debtor or to the investor? Anyone?
Yeah, being an unsecured creditor, the money is at high risk. The first one.
Yes, sir. The money is at high risk, and that is why there is always a challenge with resolution professional how to say get these interim finance, because it is very hard to convince people to invest in such a corporate debtor which is already undergoing CIRP or liquidation, whatever the case may be. So that is one of the disadvantage. There is one more disadvantage, if you can just think of any one of you. It is with respect to the interest amount. I'm giving you a hint. Is there any bar, or is there any limitation on the interest value, or it is endless time
No,
period?
ma'am, I think there is no bar as per the interest rate is concerned. Depends on who is providing the amount, money. And whether it is agreed by the COCs, and it goes on.
So in CIRP, it goes on, or in liquidation also it goes on, sir?
In CIRP.
In CIRP it goes on. And what happens when a corporate debtor goes into liquidation? What will happen to the interest amount of
Yeah, when you distribute the asset, then this amount will be on at priority.
So suppose the company goes into liquidation, and it takes around 2 years to liquidate all the assets. So for all the 2 year period, for the complete 2 year period, will the person who has given interim finance, will he get the interest for full
Yes,
2 years?
absolutely. Yes.
Any other view? Because there is something attached to it. Any other view? that is what the disadvantage is. That is what we will see in later parts of our slides. What is the disadvantage? So just keep this in mind. There is something involved, which is, one is the risk part, which you have said that is a big disadvantage. And the second part is the interest element also. The full interest is not paid to them, sir. So that is what we will discuss in later parts of our slides. Again, one more question which comes to our mind here is how to encourage the institutions to provide interim finance. And basically, it is the duty of the resolution professionals to, persuade others or to convince the institutions and to ask them for the interim finance. So, is there any strategy which you can guide us how to do that? Because it might happen that COC is not willing to provide funds. You can opt for some outsider. So if you are approaching any outsider, is there any strategy which you should follow or how you should proceed for that? So that is again a kind of question, how to encourage the institution, because you will have to say the benefits. The biggest benefit is the repayment, that is the priority of repayment. That is what you can basically talk about. And also, while going to all these institutions, what you should have is a strong background or the strong knowledge of the assets of the corporate debtor, because normally institutions, these financial institutions, they invest in those particular corporate debtor wherein they find that there is a real value of the asset is available. So if you have a good uh, background of a good worth of the corporate debtor, then of course you can get the funds very easily. But again, for that you'll have to study about the all the assets about the corporate debtor, and then only you can figure out how you can proceed to the institutions for us for asking them for the funds. What are the basic considerations of a finance provider? Suppose you are one of the finance provider. How will you take this if anyone approaches you for the interim finance, asking for an interim finance in such a corporate debtor which is already in CIRP process? So what will be your considerations? How you will, what will be your terms and conditions while providing any kind of interim finance? So that is again a question which comes to our mind. What are the basic considerations of the finance provider? Will they be asking for the collateral? Will they be asking for a higher this interest rate? And the other conditions may also be there. So obviously they will be asking, and how you can handle that in a very polite manner or in a very systematic manner, that is up to you, and that is where the skills of RP involves. Next question is how this is repaid, the interim finance, how this is repaid. So I think some of you have already said that this has a priority, priority is there in section 53, where the waterfall mechanism says that it is a part of CIRP cost, because this interim finance, basically it is considered as a part of CIRP cost and liquidation cost. So this will be paid in the priority to all other debts. So it is already mentioned in the code itself that if there are two different sections, see, if the corporate debtor is under CIRP and it is having a proper resolution, simply meaning that it has a proper resolution applicant who has given a very good resolution plan where it is approved by COC and NCLT and all. So the basic criteria while checking that resolution plan is given in section 30 itself. It says that if the resolution applicant has already provided for the payment of interim finance, then only you can consider it as a good resolution plan. That is one of the factors. I'm not talking about all the other factors. I'm just taking one which we are concerned with. So if the resolution applicant has not provided regarding the payment of the interim finance, then that resolution plan should not be accepted at all. The basic criteria of a resolution plan includes the payment or the repayment of this interim finance or the interim cost, whatever it is involved. So that is a part of a good resolution plan. And if it is not there, then it is the option available with the resolution professional that they may simply reject that. And that is the thing when CIRP is continuing and we can have a proper resolution of the corporate debtor. But suppose a proper resolution is not happening, and then in that situation, the corporate debtor will go into liquidation. And if the corporate debtor is going into liquidation, then again, Section 53 says that they will have a priority at the time of payment. So in both the scenarios, whether in CIRP or liquidation, in both the scenarios, they are this interim finance providers, they are given the priority or the super priority of the payment. So in both the circumstances, their amount will be paid off. But there is a twist to it regarding the interest part. In CIRP, the full interest is normally paid, but in liquidation, it is mentioned that there is a time period attached to it. So normally 12 months is the time period. Beyond that, it is not paid, the interest part. That also we will come to see later. Priority order, we have already seen that they will be paid in priority. The next question is what will happen to the interest on interim finance? This also we have discussed that along with the principal amount, interest is also taken on a priority basis, and that is also repaid along with the principal amount. What if company goes into liquidation? This also we have understood. A kind of, we are just having general discussion. We will see all these questions in detail in some time. So can there be an accumulation of interest? So this accumulation of interest is basically, you are adding up interest again and again, like in case of liquidation, because you are not paying them off then and there. So you are accumulating the interest, maybe months on months or year on year basis. So how far this accumulation can go on? So again, there is a restriction, and that is what we are saying, that the whole amount of interest is not paid. So accumulation is allowed, but it is allowed to a certain extent only, and therefore whatever amount is of interest is not accumulated, that becomes a disadvantage for the interim finance providers. So all that is linked, and we will all study that one by one. There's one more question. What are the challenges faced by RP in raising interim finance? As I've already said, that it is very difficult to convince some institution or external these finance providers to invest in such a corporate debtor which is already undergoing liquidation or the CIRP process. So it is very difficult to convince. So that is the basic challenge which a resolution professional faces. And if obviously you can have it from COC, nothing great than that. But sometimes it happens that they do not reach to a conclusion, and therefore we require some external funding also. So therefore the challenge arises for the resolution professional. So we will understand how to face that challenge also. So let us go step by step. Firstly, let us discuss what is the legal definition given under the code for this interim finance. Can any one of you tell me what is the exact section where we can find this definition of interim finance? You can just take a chance and let us know. Any one of you? Okay, I'll proceed with it. It's section 5, subsection 15, where it says that interim finance means, as you can see, there are various kinds of definitions. One definition is it starts with means. So means means nothing beyond that you have to see. So whatever written here will be taken as the definition, and you don't have to consider anything else. Sometimes we see that the definitions are inclusive in nature. So they provide various kinds of things, like in case of income tax, we see that the definition is inclusive in nature. So they say that rent, if you are having a rent, you are having a salary, or you are having a business income, all that is considered as income. So it is inclusive in nature. It has provided various categories. So that way it is inclusive. Sometimes definition is not inclusive. So it says that except this and this, everything will be considered as a uh, uh, that will come under the definition. So there are various categories of definitions. What I mean to say here is that interim finance is such a definition. It is clearly given here that you don't have to think anything else. You just have to focus and concentrate only on the words which are mentioned here, because it says or it starts with the word means. So nothing beyond this you have to see. So what is interim finance? I have broken it down. I actually broken it down into a simple language so that you can easily understand it. So it starts with a word that it is a financial debt. So what is a financial debt? What is an operational debt? We all understand, because that is how we are segregating between operational creditors and this financial creditors. So normally a financial debt, if we say, then in that case, the unique feature is that it comes along with an interest cost. So if you are charging any interest, it is given in the form of some kind of loan, or as we say, time cost is there. Then in that case, it will be considered as interim finance. So uh, suppose if your day-to-day supplier has given you some more time period to repay, will that be considered as a kind of interim finance, or a facility given to you in the nature of interim finance, or some advance is being given by some of your customer, whether that will be considered as interim finance? So the answer is simply no, because they are not a financial debt. So firstly, while classifying whether it is an interim finance or not, because if you are considering the same thing as interim finance, then it will have a priority at the time of payment. That is why we have to be very careful. So suppose if we are ourselves raising interim finance, again, if we are not sure of how to raise the finance, it should be raised from the operational creditors or the financial creditors or some external parties. So if you are raising the funds from your operational creditors, that will that amount to interim finance? Because if you are raising it from your operational debtor, but again, if it involves some kind of interest, then it may come into the category of interim finance, because from any individual also you can have this kind of interim finance. The source is not mentioned here. It is just saying that interim finance means any financial debt. I think the first part is clear. You can let me know wherever there is any confusion, or we can, if we have to discuss something in detail, then we can stop there and we can discuss. So first thing we have discussed that it is any financial debt. Second thing, it is saying that it is raised by the resolution professional. So normally interim finance will be raised by the resolution professional only during the insolvency resolution period. So does that mean any funds which were raised before CIRP started, will that be considered as interim finance, or it will not be considered as interim finance? This definition makes it very, very clear that any earlier funds which you have taken, be it in the nature of financial debt also, cannot be considered as interim finance, because it is simply clear cut mentioned here that it is raised by resolution professional, and also during the insolvency resolution process period only, the funds raised will be known as interim finance. So any amount which is raised earlier or prior to CIRP, that will not be considered as interim finance. Am I clear till here? Can we proceed, please?
Yes, yes.
Yeah. Again, as we know, there is a separate procedure for MSME. This pre-pack insolvency resolution process is there for them. So in this definition itself, amendment was made saying that this interim finance can also be raised by corporate debtor also, but during the PPIRP process. So if the CD is undergoing this PPIRP process, that is pre-package insolvency resolution process, then in that case, because all the functioning, all the process is done by the corporate debtor themselves, then they may raise the funds, and that fund will also be known as interim finance. While in all other cases, like in all CIRP cases, only this resolution professional will have the authority to raise the funds, right? And it is also saying and. So till here, we can just read it in one go. So interim finance means any financial debt which is raised by resolution professional during normal CIRP or corporate debtor during PPIRP. So this is just one part. And it is also saying and. So whatever is mentioned now will also be considered as interim finance. So here it is saying that such other debt as may be notified. So who notifies? We all know that the central government notifies normally. So whatever debt which they have notified, or they have clearly mentioned that this will be considered as interim finance under this particular category, then without any doubt, that will also be considered as interim finance, though it is, it is not fulfilling the first part. Even if it is not fulfilling the first part, then also it will be considered in this category. Am I clear till here? Can I proceed, please? See, this I'm asking again and again because
Yes.
in this Zoom meeting, normally what happens that I cannot see faces of all those who are listening or not. So again and again, I have to check whether you all are there or not.
Yes, yes, please.
Yes, sir. So it is the notification which was, or which is basically related to this interim finance. So this is a very good thing. If you are not aware, then this is something new for you all to learn today. So what is this notification? See, this was issued by MCA, and this was issued on 18th March 2020. I'm reading it from here. In exercise of the powers conferred by clause 15 of section 15 of the Insolvency and Bankruptcy Code. So what is 515? We have just understood that this is the definition of interim finance. So for the purpose of this definition itself, the central government hereby notifies a debt raised from the special window for affordable and middle income housing investment fund 1 for the purpose of the said clause. Simply meaning that central government has here notified that if any fund is raised from this special window for affordable and middle income housing investment fund, in short, it is known as Swami Fund. S, you can do the short form here, special S, then W, SWA, affordable, then M for middle, so SWAMI, that is income, and then H, SWAMIH, investment fund. It is basically known as the Swami fund. So for the purpose of this particular clause, if you have raised any kind of fund, then that fund will be considered as interim finance. Let us first understand what is the meaning of this, because the explanation here itself says what is the meaning of this fund. So for the purpose of this particular notification, the expression special window for affordable and middle income housing investment fund 1 shall mean again, it is a clear cut definition, you don't have to see anywhere else. So it shall mean the fund sponsored by the central government for providing priority debt financing for stalled housing projects as an alternate investment fund and registered with the SEBI, established under subsection 1 of section 3 of SEBI Act 1992 to provide financing for the completion of stalled housing projects that are in the affordable and middle income housing sector. So what is here conveyed to us is simply that this particular notification, or this particular notification, basically it is in addition to this interim finance definition, which we must consider while understanding what is the meaning of this interim finance. So this notification, as you can see, it is providing a sponsored fund by the central government under this particular fund, which is investment fund, which is known as special window for affordable and middle income housing. So normally it is for the real estate sectors. So all those who are engaged in some kind of assessment this assignment related to this real sector, then in that case you can always go to uh, 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 this government particular investment fund, where you can easily seek the interim finance. You have to follow the procedure obviously, and then you can seek funds from there, and this will be considered as interim finance. The question arises is some because as I told you that this is provided through a notification, so it may not fulfill the criteria which is given above. So it may happen that some real sector corporate debtor has already taken the benefit under this particular scheme even before going into CIRP. So if simultaneously some CIRP process takes place, during time the CIRP process also takes place. So will the fund which was obtained before CIRP, will that be considered as interim finance as per this notification or not? That is a question. See, if you are taking it during CIRP, then there is no doubt about it. It will 100% be considered as interim finance. The question is, because it is nowhere mentioned that only in this notification, nowhere it is mentioned that only entities which are going under CIRP have to take this fund, have to take interim finance as such. So anyone can opt for this fund. It is not that if you are undergoing insolvency, then only you can apply for this kind of fund. Anybody who is fulfilling the criteria which is mentioned as per the scheme, firstly it should be mentioned in the it should be categorized under the RERA scheme. Then obviously it is, as it is said, that it is for affordable and middle income housing investment projects. So there, if those people are categorized in this particular uh, category, then in that case they can easily avail the funds which are available. So it is not necessary that you are going into liquidation and then CIRP or liquidation, then you are applying for this kind of fund. You can apply it beforehand also. But the question arises whether, if you have already taken this kind of facility, you already have this kind of funding, then whether that funding will be considered as interim finance, or it will be taken at par with other creditors, because this was taken before initiation of the CIRP proceedings. So this is what I would like to know from you all. Am I making myself clear? I'm asking, if you are opting for such kind of funds, if a entity has already taken such kind of funds before initiation of CIRP, whether that amount will be considered as interim finance, or will that be given a priority? As we have seen that if it is considered an interim finance, it will be given priority. And if it is not considered interim finance, it will not be given priority. So what is your say in that regard? Any one of you? And again, there is a question regarding the interest part also in that case. Can anybody answer? Have I made myself clear? There could be two scenarios. One is you are getting this facility during CIRP. Then in that case, 100% it is considered as interim finance, and whatever interest is involved, or whatever interest is charged, that will be taken as the CIRP cost only. But what if this finance was taken before initiation of CIRP proceedings? What will happen in that case?
It will be considered as interim finance because it will be a notified debtor as per the
100%, sir, 100%, because as I have already mentioned that this will be taken as it is interim finance. Whatever is notified by any government authority in this regard, that will be considered as it is, irrespective of the time, whenever you have taken. And so that is why the interest element also will be considered in the same fashion if it is considered as interim finance. So the outstanding, normally what we do is, suppose SBI has given loan to a particular corporate debtor, then as soon as CIRP starts, we have to calculate interest till that date only, when before CIRP proceedings start. So we cannot continue the interest element during the CIRP because moratorium has started. So calculation of interest stops at a particular, there's a cutoff date normally. But in case of this interim finance, it will continue. That is the major thing, major takeaway, which you should understand, that if at all any debt is considered as an interim finance, its interest will be paid in priority, and it will be continued to accumulate. But the something is there in case of liquidation, which we will study, that only for 12 months period it is given. It is not given beyond that in liquidation. Can I move further? For this particular thing, we will discuss in detail again what are the projects which are considered in this particular special window for affordable middle income housing investment. I'll take you through the website, and there we will discuss the real life example cases also. We can discuss who all have been benefited under this particular scheme, so whether it is actually helping out or not. So that is something which we can discuss later. But it should be understood at this point of time that there is some kind of scheme, there is some kind of notification which clearly says that for real estate projects, specifically for affordable and middle income housing projects, for that particular category, we have interim finance available from the government themselves. They have sponsored funds for this. So if you fulfill the criteria, you can easily avail interim finance from the government themselves. So the next question which we were talking about, what is the need of this interim finance? I think I can go a little fast on this. So for the operational continuity, to continue the regular operations, for the preservation of value, because the ultimate crux of IBC is to have value maximization, or the value of the corporate debtor should be, we should seek the highest value from the resolution applicants. So if you are not maintaining the regular operations of the entity, if you are not taking it as a going concern, then obviously its value will go down. So in order to continue the operations, obviously you will require funds to pay out the salaries, to pay the electricity charges. As we all know that these are something which are required on a continuous basis, which you have to provide for. So that, for that particular reason, we need to have funds available with the corporate debtor, or else we can provide, or we can take it from the external people also, or from COC, wherever. So in order to preserve the value of the corporate debtor, so that you can have a maximum quote or the maximum value while having the resolution plans. So that is again a very, very important factor for needing this interim finance. The next is to avoid liquidation, and it increases the chances of successful resolution by keeping the company afloat. So if a company continues its operations, it is having sufficient funds to continue the operation, it might happen that it does not require any kind of liquidation. It might resolve during the CIRP process itself. So in order to avoid the liquidation situations, then also we can understand that there is a need of interim finance. Now, what is the authorizing provision? Authorizing provision simply means where in the code or where in the regulations it is mentioned that one can seek this kind of interim finance, and who is the authorized person to do so. So that is what this authorizing provision talks about. So basically it says that IRP shall have the authority to raise this kind of interim finance. IRP or RP, whatever the case may be. Basically, it is given in section 20, which talks about management of operations of CD as a going concern. So as we all know, it is the duty of a resolution professional to continue the operations of corporate debtor as a going concern. So in order to make the corporate debtor, or to run the corporate debtor as a going concern, we are in need of funds. So in order to fulfill this particular section or the obligation of this section, this resolution professional has the authority to raise funds. So it is coming with the authority is not directly given to you. It is saying that it is first of all your duty to continue the corporate debtor as a going concern. So because it is my duty to continue as a going concern, then in that case, I am being given, or the resolution professional is being given the authority to take respective measures how to continue it further. So if you require funds, you can raise that also. But again, some conditions are attached to it. You cannot directly take the funds as much as you can. So section 22C, exactly this is the point where it is mentioned. It says that to raise interim finance, it talks about that IRP can raise interim finance provided the condition is mentioned here that no security interest shall be created over any encumbered property of the corporate debtor without the prior consent of the creditors whose debt is secured over such encumbered property. So what care is to be taken while raising the interim finance is that you cannot provide security interest on the encumbered property already. So if a property is already encumbered, you have to seek the prior consent of the creditors who on whose name this property has been encumbered. So normally they won't provide any kind of consent for such thing. It it is a general perception. So normally you cannot have security interest on the encumbered property. If you have some properties which are not encumbered, then of course you can proceed with that. So security interest on encumbered property cannot be created. This is to be taken care while raising the interim finance. And if you want to if you want to create some kind of security interest on the encumbered property, then again you have to take the prior consent of the person on whose name that is existing in earlier scenario. There is again a proviso attached to it, provided that no prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to twice the amount of the debt. So accordingly, you can judge whether the consent is required or not, and that way you can proceed. So again, as I was telling you, this authority is not directly given in the section. It is indirectly given to us in order to protect and preserve the value of the corporate debtor. If you think you require interim finance, you can raise that. So again, the burden of proof is on the is on the resolution professional. He has to justify that to protect and preserve the value of the corporate debtor or to manage the operations of the corporate debtor as a going concern. I had to I have no other option but to raise funds. So this is what he has to prove, and this has to be taken care by the this has to be considered at the time of COC meeting also, and then COC approved, then only this interim finance can be raised. This RP or IRP cannot directly do anything on their own. They have to seek the permission of the COC also in order to do anything. But again, they have to establish that yes, there is a need because of these two reasons. So these two are the primary reasons which you have to justify wherever interim finance is raised. So everything is to be documented. This is to be taken care. How you arrived at a particular quantum of interim finance. Again, that calculation, that estimation should be with you. So only then you can, proceed with the proper legal procedure. Again, in section 25, it is mentioned that it is the duty of RP. What is the duty of RP? It is mentioned in section 25 2C, RP to raise interim finances subject to the approval of the committee of creditors under section 28. So there's no doubt that RP can raise interim finance, but again, it is subject to the approval of COC, and which is again given in section 28. So section 28 basically talks about approval of COC for certain actions. So I'm not taking the whole section, but whatever is relevant, we are discussing that only. So section 28(1)(a) clearly says that prior approval of COC is required in case of raising any interim finance, which is in excess of any amount as may be decided by the COC in their meeting. So in short, what we are seeing that while raising funds in the nature of interim finance, firstly, it should be discussed in
Not able to hear.
I think connection has been lost. Ma'am, we cannot hear you. Please unmute.
Sorry. Till where could you hear me? I'm not sure. So I'll be just sharing the screen again, and probably then you can guide me where I need to start again. We were here, authorizing provision. Could you all follow till here? Authorizing provision?
You were
Can you
talking
see?
about 28.1.
Yeah, 21A, right. Okay, so they have not missed much. So I was just saying the crux of this particular section. Whenever RP is given a responsibility that he can raise funds, but again, there is a condition attached to it. The condition is just that he cannot raise funds on his own wishes. He has to take a prior approval from COC. So if he has obtained an approval of raising 1 crore of funds, and meanwhile he meanwhile he sees or he foresees that we would require some more funds, suppose 0.5 crore more we would require. He cannot do that on his own. He will again has to seek a prior approval of COC in order to raise excess of interim finance, whatever was decided earlier by the COC. So in short, whenever funds are to be raised, there is no bar how many times you can raise this kind of interim finance. You can raise it n number of times, but again and again, you have to seek approval of COC. Am I clear till here?
Yes.
Okay. So what is the relevance of this interim finance? Again and again, as we are talking about, we have just discussed the definition of interim finance so far. Now, if something is categorized as interim finance, what will be its relevance? That is what we are discussing now. So if something is categorized as interim finance, if it falls under the definition of interim finance, then we have to see these respective sections. Section 513, what does it talk about? It talks about the definition of insolvency resolution process cost. Here also the definition start with means. So there are various sub-clauses attached to it. We are taking just one of the sub-clauses because that is only relevant for our discussion. It clearly says that the amount of any interim finance and the cost incurred in raising such finance. So it clearly says that any resolution process cost, here the CIRP cost, I would say in short, it would simply mean any amount of interim finance. Suppose we are raising 1 crore of interim finance, so that amount is no doubt considered as CIRP cost. And the cost incurred in raising such finance, that means any interest if it is involved in raising such finance. So suppose 5%, I'm saying it very less, so 15% or 25%, suppose that kind of higher interest rates are also there. So that will be considered as the cost here, and that will be considered as the part of CIRP cost. One thing. Similar provision is given for PPIRP also. So section 523C, it clearly says that PPIRP, that is pre-packaged insolvency resolution process cost, would mean, again, there are various sub-clauses for that. So first, A clause here says that the amount of any interim finance and the cost incurred in raising such finance. Again, the same definition is there, but since we know CIRP process is different and PPIRP process is different, so for both of them, they are considered this interim finance as well as the cost of incurring that interim finance, that raising that interim finance will together be considered as CIRP cost or PPIRP cost. And if it is considered as this insolvency resolution process cost, what would that imply? So step by step we are discussing. Firstly, if there is a financial debt, if that financial debt is categorized as interim finance, then that interim finance along with the cost will be considered as insolvency resolution process cost. And if it is considered as this insolvency resolution process cost, that is CIRP cost in short, then the impact or the significance is that it will be provided for the prior payment, or it will have a priority in the payment. That is what is mentioned in section 32. So normally section 30 is talking about the submission of the resolution plans. So I'm directly taking this subsection 2 in that the resolution professional shall examine each resolution professional. So read the words. Here it is the duty of resolution professional that he will examine each and every resolution plan which he is receiving to confirm that each resolution plan shall have these following items, shall have these following elements. So one of the elements which is mentioned here is it provides for the payment of insolvency resolution process costs in the manner specified by the board in priority of the payment of other debts of the corporate debtor. So let us take an example. Suppose there is this resolution professional has received a resolution plan where he's saying that I am ready to pay all the insolvency resolution process cost, but I'll be paying them at third or fourth priority order. I'll not be paying that at the first level. So that will not be considered as a good resolution plan, and it should be rightly rejected just for the sake of this section, because it clearly says that there has to be a priority of the payment in case of CIRP cost. Suppose let us take one more example. If in the resolution plan he has mentioned that he will take care of all the creditors, he will pay out all the creditors, but he has not mentioned in that resolution plan, the resolution applicant has not mentioned that he will pay any of the CIRP cost, or he will proportionately pay CIRP cost. Then again, in that case, that particular resolution plan will not hold good. It will again should again be rejected just for the sake of fulfilling this criteria, because here it says two things simultaneously. One is the resolution plan should provide for the payment of resolution process cost, and that payment order should be in priority to all the other payments of the it should be in priority of all the other payments. That is what you should consider. So two things have to be considered, and it is the foremost duty of the resolution professional to check in each and every resolution plan that whether the CIRP cost is provided for the payment or not in the resolution plan, and what is the order of the payment. Both have to be seen simultaneously. Am I clear till here? So that is why it is simply known as it is having super or top priority in the CIRP. That is what the relevance of this interim finance. Am I clear till here, please? You'll have to say, then only I'll proceed.
Yes, madam, please go ahead.
Yeah, because I think we will take a break, but after half an hour. I don't think you require tea at this time. We can continue some more time and then we will break for the tea. Again, for the relevance, again, we are checking it in the scenario of liquidation. Again, as we have seen that in liquidation also, this kind of interim finance will hold priority, but where it is mentioned in section 53 in the waterfall mechanism. Simply, I'm reading from this A point. The insolvency resolution process cost and the liquidation cost paid in full. So there should not be any haircut in this. Full amount is to be paid. So again, the question arises, what is insolvency resolution process cost? What is liquidation cost? So as we have just seen that interim finance is considered as insolvency resolution process cost. It is already in the definition. It is given in the definition itself that if you have raised any interim finance, then that amount along with the interest will be covered in the insolvency resolution process cost, right? But we have not studied about the liquidation cost. To understand it better, we should also see the definition of liquidation cost. So here is the definition. Section 5, subsection 16, it says that, or the clause 16, it says that liquidation cost means, again the definition starts with means, any cost incurred by the liquidator during the period of liquidation, subject to such regulation as may be specified by the board. And this is the only definition which is given. So here nothing about interim finance is mentioned. So it is just saying whatever cost liquidator has incurred during the process, during the period of liquidation, subject to the regulations. So again, we have to study these regulations. So for that reason, we are having this regulation 21EA of liquidation process regulations. It is talking about this liquidation cost. Again, here a definition of liquidation cost is given. So liquidation cost, to understand what is liquidation cost, we should understand two provisions simultaneously. One is mentioned in the code in the section 516, and second is given in the regulations, and the regulation number is 21EA. Both of them talk about the liquidation cost definition. So here it is again referring, you can see that it is referring to 516 of the code. So therefore, I have skipped the earlier part. I'm just directly taking 4th, 5th and 6th clause. That is more relevant for us. So here it is saying that what is liquidation cost? It simply says that liquidation cost means, again it means, and various elements are given. I'm directly taking 4th element, cost incurred by the liquidator for preserving and protecting the assets, properties, effects and actionable claims, including secured asset of the corporate debtor. So again, the nature is very much clear. It has mentioned that in order to preserve and protect the assets or the properties or any other thing of the corporate debtor, if any amount has been, if any cost has been incurred, that will be considered as liquidation cost. Fifth clause here says that cost incurred by liquidator in carrying on the business. So again, going concern nature, whatever words which you saw in CIRP provision, similar provisions are given in liquidation proceedings also, but they are given through this regulation. So if any cost is incurred to preserve and protect, so if any interim finance is raised for this purpose, or any cost is raised to carry on the business of the corporate debtor, even if it is not in the name of interim finance, then also it will be considered here. Then again, third, the last point which we are seeing is 6.6 clause, interest on interim finance for a period. So here is the key takeaway for today. So interest, here is talking about interest on interim finance for a period of 12 months or for the period from the liquidation commencement date till the repayment of the interim finance, whichever is lower. So this was the question which I asked in the very beginning, whether the whole interest is paid on this interim finance, or is there any deviation in that. So in case of liquidations, 100% interest, whatever is accumulated is not paid. The category, the time period is mentioned here. The interest on interim finance only for the period of 12 months or from the period, for the period from liquidation commencement date till repayment of the interim finance, whichever is lower. Let us take an example to understand it in a very simplified manner. Suppose a corporate debtor enters into liquidation. So let us assume that it has entered into liquidation on 1st April 2023. So that will be considered as the liquidation commencement date. So from that date, if the company, if the corporate debtor could, if the assets could not be realized and the amount could not be paid, suppose till date. So today it's 24th June 2024. So it's around 1 year and 3 months also. So we are taking it that way. So the interest element will be restricted till 12 months period from the date of liquidation commencement date. The other part which is mentioned here is till the date it is finally repaid. So it has not been repaid so far. So till date, since it has not been repaid, so the lower period will be considered. So lower period is of 12 months. So only for the 12 months it will be paid. The interest amount will be paid for only 12 months. Let us take a different example. Suppose the liquidation commencement date is again that 1st April 2023. Within 6 months itself, the company was, the corporate debtor or the resolution professional, I would say, the liquidator could realize the assets and could distribute the value of the value to the creditors and everyone. So the payment was done already within 6 months. So interest amount till 6 months only will be considered. Interest for 12 months will not be considered. I think this is very much clear. If the liquidation has, if it has, if the all the assets have been successfully liquidated and the amount has been paid, if that has taken longer than 1 year, then interest of 1 year will only be paid. But if the realization has taken a shorter period than 1 year, then the shorter period interest will be given to the interim finance providers. I think this part is clear with this particular point, and this is the disadvantage. That is why some financial providers, they are not providing finance, just because of this point, that our interest will be lost in case the corporate debtor goes into liquidation and it could not realize the assets. So that is a drawback, which is mentioned here also, that only the interest portion till 12 months will be given. If normally, because the IBC code itself says that the liquidation should take place within 12 months. They do not want to, prolong the proceedings. So that is why this is mentioned here, that at least you should try to finish it up, wrap it up within 12 months itself. But even though if it is taking longer time, maybe due to the reason that some properties are under litigation, or you are not getting good value for that, or you are not able to actually sell the assets, maybe some reason or the other, then in that case, because the liquidation proceedings go for a longer time, even more than a year or two, then in that case, the interest will not keep on accumulating. It will stop after 12 months. That is the only takeaway.
Do we have any restriction in the CIRP also?
So normally CIRP process ends where you have a proper resolution plan. And if
resolution plan passed by COC or NCLT?
So if it is passed by COC, and then obviously it should pass by the NCLT also, na sir? Final approval is given by NCLT.
नहीं, देखिए, जैसे मैंने अगर पैसा दिया हुआ है एज इंटरिम फाइनेंस एक कॉर्पोरेट डेटर को,
हाँ जी,
और मेरे को अभी पैसा नहीं मिला है, सीओसी ने रेजोल्यूशन पास कर दिया है, बट वी हैव अ लिमिटेशन ऑन द पीरियड आल्सो इन सीआरपी.
गॉट योर पॉइंट कि लिक्विडेशन में तो सर ये चीज लिखा हुआ है, उसमें सीआईआरपी में ये चीज मेंशन नहीं है.
ऑलराइट.
हाँ, तो they will be paid till the point of time when they are actually paid.
Actually, it will be paid by the RA.
Yes, sir. Finally. That will be paid by RA, obviously.
Whether it goes for 330 days or 2 years.
Yes, sir. Yes, sir. That will be mentioned in the resolution plan itself, that he will bear the cost. That is the thing. But here, there is a restriction given in the liquidation proceedings that he will not have the finance cost, this interest cost, more than 12 months. Can I proceed?
Please, ma'am.
It's steps involved. I think the spelling is not correct. So how to understand or what are the steps involved? How should you take up this whole process? So if you are a resolution professional and it is one of your assignments to analyze how much interim finance should be taken. So what is the first step? The first step is whether you are in need of funds or not. That is what you have to analyze. So first is the assessment of the need. The resolution professional must assess the financial requirements of the corporate debtor to continue operations during CIRP. Obviously, this it simply wants you to have a broad understanding of the operations, what all cost is involved, what is the operational cost which is required, and whether the corporate debtor will be having sufficient funds to bear that cost or to continue as a going concern, whether you have sufficient funds or not. That you have to assess, make an assessment of it. For obviously, for all these things, you can take external help. And if you are hiring anyone to assess all this thing, then whether that person will be paid, how much that person will be paid, that all is decided in COC. Normally, it is your duty to do, but again, obviously, you can seek professional help. Then formulating a proposal. Once you have the proper assessment, you have the proper analysis, that suppose I need 50 lakh of funds, or I need 1 crore of funds, or maybe more than that, then if you have a proper structured assessment, then you have to formulate a proposal, because it is not that you can directly go out and seek funds. You have to first get it approved in the COC meeting. So for that, you have to properly formulate your proposal. The RP prepares a detailed proposal outlining the necessity, amount, terms, and conditions of the interim finance. So before going to COC, he must be thorough enough. He must have done proper market study. What are the terms and conditions if it is raising any interim finance? So it has to get the quotations also from the external parties. How much rate of interest is charged and what are the specific terms and conditions. Everything he must be aware of, and that is to be documented also. And what is the actual need? That is what we have to justify. Whether we are actually in need of funds or not, that is something which you have to justify. The proposal includes a plan for utilization of the funds and expected benefits in terms of maintaining business operations and asset value. So besides the first point, again, whatever funds you are having, how it will be utilized, and what will be the expected benefits also, that you must also be able to tell. Suppose if you are if you want to continue with the license, then this much is the cost involved, that you have to mention. And if we continue with the license, what will be the expected benefits? Like in telecom sector, we need to have a license continuing. So in that way, you can always mention this kind of thing. Next is approval from the COC. The RP presents the interim finance proposal to the COC for the approval. The proposal is discussed in the COC meeting, where creditors evaluate the necessity and the feasibility. Approval requires a majority vote, that is 66% of COC members. Then again, documentation, what all documentation is required. Upon approval, the RP and the interim finance provider draft and finalize the necessary legal documents, including the interim finance agreement. The documentation details the amount, interest rate, repayment terms, security collateral, if any, and other relevant terms. Then again, you have to intimate it to the NCLT also. The RP must inform the NCLT about the COC's approval for transparency and record keeping. So anyone is aware of how you have to communicate this to NCLT? Is there any proper format, specific format to do that, or simply you have to convey? Has anyone done that? No idea? It's CIRP 6 you have to file. That also we will take it up in the next slide. So while intimating NCLT, and what is the time limit within which you have to file that CIRP 6? That is also mentioned in that. So in short here, till this slide, we must understand that we do not have, it's not just that we have to take the permission of COC, we also have to inform. It is not that we have to take approval from NCLT, it is just that we have to inform within the time limit to NCLT. This ensures that the decision to raise interim finance is officially documented and available for review. Then next is the disbursement and utilization procedure. The interim finance is disbursed according to the agreed terms. Like it may be disbursed monthly or quarterly, or whenever you require, how the terms are agreed between the parties, and how it is utilized. That also again you have to keep a check of, or you have to monitor whether the funds are utilized properly or not. The RP ensures that the funds are utilized strictly as per the approved proposal to maintain operations and preserve the value. This is the procedure. If you are raising interim finance, then CIRP 6 is to be filed. And who is supposed to file this? Either IRP or RP, as the case may be. Within 7 days, it is clearly mentioned, within 7 days of the occurrence of the relevant event. So whenever you have got the approval, whenever you have raised the funds, in that case, you have to provide this CIRP 6 form. The IBC outlines a clear structure for raising interim finance requiring COC approval. Interim finance enjoys super priority status, boosting lender confidence. So this is something which we have studied so far, This is the crux, that everything is given in IBC and the power is with the COC to approve this interim finance, and later on, that management or the execution part is with the resolution professional. And whosoever is giving the interim finance will obviously have a super priority in the case of repayment of that particular thing. So before delving into the complications, let us first understand whether this kind of scenario is available in what kind of scenario is available in the other parts of the world. So since IBC is not only happening in India, obviously it is taking place in many other parts of the world well before it existed in our country. So that is what we need to understand. So let us talk about the United States. The framework there which they have is the US Bankruptcy Code. It particularly talks about that in Chapter 11, it includes the provisions for debtor in possession, that is DIP financing. DIP financing is secured by a super priority status, often backed by a collateral. So there they have a separate procedure. There they call it debtor in possession model. Like in our case, in PPIRP, we call it debtor in possession because corporate debtor will have the possession of the assets of the company, or he will be still caretaker of the company. But in normal CIRP proceeding, it is the other way, creditor in possession case, because now the management does not have any role to play. Everything goes to COC, or indirectly it goes to RP. So that is why that is a different scenario in India. But here in United States, it is debtor in possession financing, which is provided particularly in Chapter 11, which talks about this interim finance provision. And again, the same thing is mentioned, super priority they will enjoy. What is the advantage there? They have a proper developed market. So a mature market with many institutions specializing in debt financing. Like here in India, we don't have this kind of model where any specific institute is allocated with this kind of specialization in this particular financing. So everyone is doing everything kind of in India. But there we have a specific model that there some institutes are specially dealing in DIP financing. Again, the competitive cost is there, the lower financing cost due to a very competitive market. Since here we do not have such thing, we have higher cost. There is a flexibility also in the legal framework allowing for financing arrangements. But again, since this is at a very evolving stage in India, maybe in future we will have some kind of flexible legal framework with respect to this. Next is the case of United Kingdom. Here the UK insolvency law supports raising interim finance but lacks a formalized structure similar to the debt financing in US. So again, here there is a similar kind of thing, but again, a proper structure is not there, just like maybe in India. It's not that much, formalized as it is in US. So it is again at a lower level. Administration financing is available, providing some degree of priority. What are the various challenges? It is again less structured, and obviously the cautious lenders. Lenders are again, see, I'll just read it. Absence of strong super priority status results in cautious lender participation. So super priority status is also not existing in United Kingdom, and therefore lenders are, they are restricting themselves from restricting themselves from this kind of investments. Can we take up some case laws? Or you want to break?
I think we can break and then take up cases.
As you say, sir, because you have only spoken, we can take a majority vote also, but as you also. So we are having a break for 10 minutes. That will be fine.
Yeah, 10 minutes.
Okay, so we will resume at 3:40 then.
Okay.
Okay. Can we start the session? Is everyone back? Can we start the session, please? Please respond if you all will have had your.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Please start.
Okay. Thank you so much, sir. I'll just be sharing the screen. Just let me know if it is visible.
Absolutely.
Okay, sir. So these steps and what we have discussed, we were on the case laws part. Global scenario we have discussed. Then so these are a few case laws which you can note with respect to the interim finance. So let us understand this first case. It is regarding Uttam Value Steels Limited. What are the facts? I've just taken a very crisp or just the summarized way I have taken it for just the understanding purpose, just to make you understand that it has been taken up in the courts also at times. So what are the facts? Uttam Value Steels Limited was undergoing corporate insolvency resolution process. The resolution professionals sought approval from COC to raise interim finance to keep the company operational. What was the decision? The NCLT approved the RP's application for interim finance, emphasizing the necessity of maintaining business operations to preserve the corporate debtors' value. This case underscored the importance of interim finance in sustaining operations during CIRP. What is the significance? It highlighted the NCLT's support for the use of interim finance to ensure that the value of the corporate debtor is preserved and that the business operations can continue uninterrupted. So again, we can see that NCLT is also mentioning it that it is very much essential if you have to preserve the corporate debtor value, and if you have to continue running the business operations, you can very well be in need of these kind of funds, and therefore you can raise these funds by getting an approval from COC. Next is Synergies Dure Automotive Limited. In this case, the RP sought interim finance to maintain operations. The COC initially had reservations, but eventually approved a certain amount. The issue revolved around the terms and extent of the interim finance. What's the decision? The NCLT clarified that interim finance must be sanctioned by the COC and should be utilized in a manner that preserves the value of the company's assets. The tribunal also highlighted that the COC's approval is paramount for raising interim finance. What is the significance of this particular case? This case reinforced the necessity for COC approval in raising interim finance and the responsibility of the RP to utilize the funds judiciously to preserve the asset value. I think these cases are making sense because the same thing is being highlighted here again and again. that you need to have such kind of, you can raise such kind of funds. Then again, we have a case of SR Steel India Limited. During the CIRP of SR Steel, the RP required interim finance to keep the operations running. The COC approved the request, but there were disputes regarding the terms and priority of the payment. It is a Supreme Court decision here, and it is a landmark judgment which upheld the super priority status of interim finance as stipulated under Section 53 of IBC. The court emphasized that interim finance should be repaid before other debts to ensure that essential business operations can be maintained during the resolution process. This ruling provided a significant boost to the confidence of the lenders in providing interim finance, reaffirming the super priority status and ensuring that the financiers are prioritized in repayment. Then the next case is with respect to Banani Industries Limited. The fact of Banani Industries sought interim finance to continue operations during CIRP. The COC approved the request, but the quantum and terms again were contested by some of the creditors. What was the final decision? The NCLT supported the RP's and COC's decision to raise interim finance, highlighting that such funds are crucial for the survival of the corporate debtor and for achieving a successful resolution plan. What is the ultimate significance? The case emphasized the NCLT's stance on facilitating interim finance to maintain business operations, reinforcing the collaborative role of the COC and RP in determining the necessity and terms of such finance. So what all we have learned so far, that has already been discussed through these case laws also, that through the COC approval, one can go ahead and proceed with raising the this interim finance. And again, the finance providers, they will be getting super priority in the repayments. That is all what all is discussed. Now there is one more case, which is Messrs. Reliance Commercial Finance. So here, Honorable NCLT, New Delhi, in the matter of Messrs. Reliance Commercial Finance versus Noble Resourcing Business and Solutions Private Limited, wherein it was explained by the Honorable NCLT that for the effective implementation of CIRP, the FC constituting the COC has to contribute to the expenses, fees, and other cost of the process. So here it is going on a different line, because here it is saying that why to go to external parties, why not COC themselves are contributing. So it is very much essential that COC has to contribute. Then again, there is a specific mention here. The Honorable Court observed that if financial creditors are not inclined to contribute to the cost of the process, then we are doubtful as to how their claim would be considered in the whole process. If the financial creditors fail to contribute toward the CIRP cost, then their claim in the CIRP process would not be considered. Though it is NCLT view, it can be argued further, but we have this kind of case law also available, where the NCLT has clearly said that if financial creditors, that means if any of the member of COC is not contributing or is denying to participate in this particular interim finance kind of thing, if they are not ready to contribute to that interim finance, then their claim would not be considered. Though this is, this can be a very harsh decision. Again, obviously, this kind of complaint will be made by the resolution professional only to the NCLT. So again, we have to be very cautious while doing so. Again, I mean, this is totally debatable so far as, because this is just a NCLT decision as we have received it. So let us see some successful stories of Swami Fund, which we had discussed in the first half of the session also. Anyone remember what is this Swami Fund? Let us have a quick test of all of you. Anyone who is aware of what is this and what is the relevance of this fund?
This was with respect to the real estate projects completion stalled. Yes, I think which you mentioned earlier.
Perfect, sir. And basically, this was related to the definition. When we studied the definition of interim finance, there the word notified was there. Any debt which is notified. So this is one of the notified debts which is considered as interim finance directly. So there are some cases where the Swami Fund has helped the corporate debtors to continue their operations, and this is one or two successful stories we will be sharing. So this is a group, Rustamji Group, which is Keystone Realtors Limited. So the name of the project is Rustamji Urbania. Because this is particularly for real estate, here whatever we will see, any success story which we will see, it belongs to the real estate category. The location, it is mentioned that this project was continuing in Thane of this Maharashtra state. What is the background? The Rustamji Urbania project, particularly the Azanio towers, faced significant delays due to financial constraints. This situation left numerous home buyers in a lurch as they awaited the completion of their homes. Simultaneously, there was CIRP also. So the project was under CIRP due to financial difficulties faced by the developer. How did this fund intervene and what was the ultimate outcome? Funding. The Swami Fund provided crucial last mile funding to the project, ensuring that the necessary capital was available to complete the construction. What was the impact? The infusion of funds facilitated the completion of the stalled projects, directly benefiting over 700 home buyers who were waiting for their homes. This intervention not only helped the home buyers but also restored confidence in the real estate market, showcasing the government's commitment to resolving issues in the housing sector. What is the final outcome? The completion of Rustamji Urbania Azeno project demonstrated the effectiveness of this Swami Fund in reviving stalled real estate projects. It highlighted the importance of the government intervention, as we have already seen. So again, there is a scope which is mentioned here, that Swami funds can be taken up as interim finance, and that way they can help. There's one more case here, Rajesh Life Spaces. The name of the project is Raj Infinia. Location is Malad, Mumbai, Maharashtra. The background is the project faced delays due to financial constraints affecting numerous home buyers waiting for their home, because the similar kind of problem will be faced, because these are the stalled projects which are wherein there are a lot of home buyers as the stakeholders, and for the residential purposes, as we have already seen, this is for the middle income group basically. So for that reason, this fund is basically established by the government to help out these real estate developers. Swami Fund intervention, they provided the necessary capital to resume and complete the stalled projects. The intervention helped in the timely delivery of the homes to buyers, enhancing their confidence in the real estate market and ensuring the project successful completion. So these are a few success stories which we have seen. Now we will be comparing various options which are available for interim finance. As we know, obviously one of the option which is readily available is the contribution by the COC themselves. But suppose if they are not ready to pay or something, ready to contribute or something, then we can go to the external parties also. So what are the external institutions which are available, and how do they vary in their terms and conditions in various other things we will see. Like we have banks, for example, SBI, HDFC, all these banks can provide interim finance. Basic terms and conditions is they provide these kind of funds at a very high rate, which is reflective of high risk nature of interim finance, obviously. They often ask for the collateral also, and repayment priority, obviously, they will be asking, and which is already provided in the code. Approval, again, they are saying that besides your COC approval, they will also consider it at their own level. So internal assessments for credit appraisal is conducted at the bank level. And if they are satisfied with their assessment, valuation, etc., then only they will proceed. So obviously in normal case also, banks take a lot, time, detailed, they do a detailed procedure, they analyze various aspects. So here also a detailed valuation will be done by the banks at their own level. They will properly assess what is the status of the corporate debtor and how their funds will be repaid and everything. And if they are satisfied, then only they will proceed to provide the funds. The next is the non-banking financial companies. These are the key players: Bajaj Finance, Tata Capital, etc. What are their terms and conditions? The interest rates here again, they having typically higher interest rates, even higher than the banks. Then collateral, they may require the collateral also depending on the company's profile. Flexibility, they are more flexible in terms of structuring and repayment schedules compared to the traditional banks. Approval, it requires approval through due diligence and COC approval. Again, they will also be conducting some kind of due diligence at their own level, and then only they will proceed for providing the interim finance. Then we have asset reconstruction companies. The key players here are this Arcel, Edelweiss, etc. The interest rates are competitive but still reflective of high risk. Collateral, obviously, they will be asking for the collaterals if available. Repayment priority, they are governed by IBC provisions ensuring super priority. Approval requires a detailed proposal and COC approval. Next is private equity and distressed asset funds. So again, these are the key players here. Again, they have a high interest rate, equity stake. They may seek an equity stake or convertible instruments as a part of their financing dealing. Collateral, they will obviously ask for collateral. Approval, regarding approval, this can be detailed, negotiations will go on in detail, and then again COC approval is required finally to settle all this. Now, what are the difficulties faced by resolution professionals? Normally, a high risk is there in raising such kind of funds, and it is very difficult to convince the third parties to invest in a corporate debtor which is already undergoing CIRP. So again and again, what we have mentioned is that there is a risk involved. First, you yourself have to be very much confident that corporate debtor will come out of this difficult situation, and then only you can convince others. Lenders are often wary of providing finance to distressed company. This we all know. I think I can directly go to the next challenge. Next is approval challenges. Sometimes they do not get approvals. It might happen that the terms and conditions with the interim finance providers, whatever is discussed with the resolution professional, is not acceptable to the COC, or it might lead to some kind of arguments or something. So approval takes a lot of time sometimes. So again and again, there is a challenge involved with RP because he wants to do everything within the time. But again, such issues might occur, and it might lead to extension of the timelines. So securing 66% is quite difficult, especially when creditors have divergent interest. The RP may face resistance from the creditors, skeptical of benefits of raising additional finance. High cost of finance. Obviously, a huge interest cost is involved, and the existing COC would not like to pay such a huge cost. So that is why there's a lot of discussion before finalizing, before approving such things. This can strain the already precarious financial situation of the corporate debtor. This we all can understand. The next is limited market for interim finance. So as we are seeing that though there are various options, but again, no one is no one can be easily convinced to provide the funds. They are not readily available. There is no market wherein you can there's no structured market, I would say. Like in US, we have, in the case of US, we have seen that there is a proper specialized separate banking for this kind of finance. So for raising interim finance, they have a separate specialized banks altogether. But here in India, we are not having that thing. So we are lacking that. And maybe in future, we will have that kind of scenario also. Okay. I'm taking up the next difficulty directly. So there are some regulatory and documentation hurdles also. So what kind of hurdles are there? The legal and regulatory requirements for raising interim finance can be complex and time consuming, because again and again you have to keep documenting everything, you have to take permissions, then again you have to inform NCLT, and that might take time for the final approval. And by the time the lenders may also think to raise the interest, looking to the scenario of the market or the corporate debtor. So the terms and conditions may keep on changing if you are taking a lot of time. The documentation process is often rigorous, requiring detailed information and stringent compliance, because whosoever will be lending funds, they will require you to provide the each and every minute detail about the corporate debtor. They want to be very much sure that their funds are safe, and they will be asking for valuations again and again. So all this kind of time taking process. Then again, building a strong case, these are the strategies which we can again, these are the difficulties, which is very simple to understand, that there is a limited market. This we have understood, and the regulatory documentation part. Then strategies to overcome this kind of scenario. How resolution professionals should handle this kind of cases. So this is what a kind of skill which we all need to develop. So first is building a strong case for interim finance. Until and unless you yourself are convinced, you cannot convince others. So that is what is meant here, that you have to build a strong case, saying that, demonstrating that the corporate debtor seems to be very, it seems to be very good in the, it seems to be very good in terms of operations. If provided funds, we can do better, and you can reflect that through the financials also, and whatever the assets, what you can disclose, all the valuations which you have, you can be ready with all the documentation part, just to show that everything is there, and there is it's a very strong case which can be portrayed in front of any of the lenders. So you have to basically highlight how the funds will preserve the asset value, ensure the operational continuity, and potentially lead to a better resolution outcome. Next is engaging with the COC members. See, rather than going to outsiders, it is better to have the COC members involved in each and everything, and convince them rather than going to others. In fact, you can ask your COC members that whatever funds you are providing now will have a priority, obviously, because it is now considered as an interim finance. So that way you can always convince your COC members. So proactively engage with COC members to address their concerns and provide clarity on the benefits of the interim finance. Use data, case studies, and expert opinions to back the proposal and show positive precedents. Then negotiating terms with the lenders. So again, obviously you have to try each and everything, do all kinds of possible solutions, whatever you have to actually crack the deal with the lenders wherever possible. So because without having proper funds, will not be able to continue the going concern nature of the entity. So to have the funds is a must. So by hook or crook, you have to have that, either through COC members or through outside or external parties. So that is up to you how you take it. Explore alternative financing options, including NBFC, private equity, and distressed asset funds to widen the pool of the potential financiaries. Then again, providing security or guarantees, that could be an alternate, and everyone would be, really eager enough to take this kind of facility if you are providing. So collateral should be available, securities or guarantees should be available just to mitigate the risk of the lenders. So it should be backed by that all kind of stuff. Enhancing transparency and communication. Maintain transparency with all the stakeholders, including creditors and lenders, about the financial status and utilization of interim finance. Regular updates and transparent reporting can build trust and confidence. So whatever you have raised funds, you should regularly prepare accounts for that, how you are utilizing it, is there anything which is left unutilized, what is the plan in your future, if you need any other funds also besides that, everything. So this is all theoretical and which we all understand how we can proceed for it, but it is always better to be planned in each and every way. Nowadays documentation is a very crucial thing, and disciplinary committee is also checking each and everything whether you have documented it for conveniently for record purposes or not. So suppose if anyone is found guilty that you have raised funds without having proper COC approval, or maybe COC has given an approval for a particular amount and you have raised funds more than that, then again you will be found guilty in that particular circumstance. So again, if you want to safeguard from any of the disciplinary cases, you should have everything documented for yourself and follow the legal procedure which is there. What is the proposed solution which we can say? The proposed solution for the IBC, here we mean by that. So for IBC regarding this interim finance, they have to develop a robust market for interim finance. Just like for the sale of assets, we have a proper structural format. Online portal is there wherein you can, say that this kind of asset we are asking you for bid. So all that kind of online portal should be available for obtaining the interim finance as well. Like introduce the government-backed guarantees or incentives to reduce the perceived risks. Also, just in the case of that real estate sector where we have that Swami fund, similarly that should extend to all other sectors also. What are the regulatory enhancements which are expected? So looking to the global scenario, what all we can take from them, what all we can improve in our code, that should be taken care, and we should try to streamline all the approval process. It should be done in a very timely fashion. That should be made very clear. Then there is a need of training and capacity building, providing training for RPs and stakeholders on managing and raising interim finance, develop standardized procedures and documentation to simplify the process. So because again and again, different banks or different institutions will be requiring a variety of reports and everything. So everything should be standardized. Proper training should be given in order to raise interim finance, what all documents are required, how you have to prepare the reports. So all that has to be standardized to curtail time. Incentivize lower cost. Again, it should be made into the system itself that whosoever is providing interim finance, they should be incentivized. Like in code itself, they are being given a super priority. Likewise, some benefits can be given to them. So implement competitive bidding process to lower the cost of interim finance. That is one of the approaches. Consider the interest rate subsidies or tax incentives for institutions providing the interim finance. So that way they will be more keen to invest into, if they are having some kind of incentive, maybe in income tax or maybe otherwise. So in that way, that will allow the corporate debtors or the resolution professionals to seek this kind of interim finance in a very easy manner. Enhance legal protections. So again, there is a scope to further enhance the legal protection which is already available in the code for the financial providers. So strengthening the legal protections from interim financiaries to reduce the perceived risk, improve enforcement mechanism to ensure compliance and mitigate the default risk. So that is it from my side. I think we are open to discuss if any questions are there.
Ma'am, in the proposed solution, I
Yes,
think
please.
best solution is that incorporate in the act itself. It should be mandatory for the financial creditor to provide the interim finance, because it will save lot of time, and ultimately any proposal will be with the approval of the COC, and COC are the stakeholders, highest stakeholders in the process, and it is for the maximization of the value of their assets only. So
Right.
I think this provision should be mandatory for the uh, financial or secured creditors to provide the interim finance.
So very rightly said, but why it has not come up so far? Any idea for that? Is it that they are not understanding that it
I
is very
don't know
basic? Yeah.
why they are not, because ultimately whatever process is to be run through, whether it as a going concern or for going through the CIRP process, inviting resolution plan, this is all in the interest and maximization of the stakeholders only.
Right, sir.
So why if it is delayed in the absence of interim finance or finance, because I have seen uh, in some cases how difficult even it is to raise from the financial creditors even.
Right, so that is why we are seeing just there is only just one decision by NCLT regarding that Reliance one, which the case which we have just discussed. They went to an extent saying that their claim will not be accepted. The claim of financial creditor who are not participating or contributing in that interim finance, their claim will not be accepted.
Yeah, that should be mandated in the act itself, so that at least this part of the problems of resolution professional or IRP or RP or liquidator is taken care by the act itself, process itself.
Of course, sir, of course. But again, it's a time-taking process. I don't know when this kind of
No, actually, Reliance issue was only limited to CRP cost.
CIRP cost, right? So CIRP costs are again it includes interim finance also.
No, we can divide it into two parts.
Okay.
One is CRP cost, and the other is the cost which is for running the company as a going concern.
Right.
Am I right?
Right, sir.
So for the second one, you cannot force the creditor.
Hmm.
But for as such, as far as CRP cost is concerned, you can file an application with the NCLT always.
Again, sir, this it is just like taking a heated discussion with the COC. Normally, they do not agree for meeting or they do not approve the decisions. Again, this will take a lot of time. So again, if it is everyone is ready to do, if everyone is ready to resolve the matters quickly, then obviously this IPC is a very good concept. But the things don't happen that way. So
Main issue is CRP cost.
yes, yes, sir. And that is why there is an urgent need of this market wherein we can easily get funds for the corporate debtor to run.
As RP, whether we are getting fund easily from the market.
So we are not getting. That is what the issue is. Sometimes the
Yes.
COC won't allow. They won't approve that because they don't want any outsider to be part
Correct.
of. Yeah, exactly. So
Correct.
that is what. So that is why we are facing a lot of challenges. So various things have to be changed in the code itself. Maybe some regulations also have to be introduced. But again, that is a time-taking process. But of course, when we are doing this kind of group discussion, we are more focused as to how we can take this thing in a better direction. If you are facing any kind of issue, how we can resolve it. So this kind of meetings or these forums allow you to interact and discuss such issues, and maybe at some level there will be some
Okay, one of
representation.
I have a question.
Yes,
See,
sir.
my plan is passed by the COC.
Hmm.
And now it is pending with the adjudicating authority for the approval.
Right, sir.
And now financial creditors in a class are approaching me to start the construction. And they are requesting me to go for interim finance. Whether I can do it at this stage. At this stage.
So financial creditors as a whole, they are asking, how is
Yeah,
it?
they have a majority. Yes, they have a majority of 80%.
So let me have the views of others also, and then I will give my views. So it's not that it is just the
Yes,
final.
if other can contribute to it.
Yeah. Let us hear from all those who are practicing. What is your take on this? So you can repeat your question so that others can understand.
Okay. My point is, my plan is approved by RS plan is approved by COC and is pending for the approval of the adjudicating authority. Now home buyers are approaching to the RP to start the construction at 1 or 2 projects. Total we have 7 projects. So my question is whether and they are asking me to avail interim finance, external interim finance. So my question is whether I can go for it at this point of time, when the plan is submitted with the NCLT.
I don't think once a plan is submitted, we because that's a comprehensive resolution plan, and in between adding something and starting with the execution of the resolution plan, I think it will be considered as a violation.
Havinder sir, normally nowadays it takes minimum 2 years to get it passed by the
right.
NCLT.
That's right. The main, you can say the stumbling block is the delay in, finalizing and getting approval from the, adjudicating authority or whatever may be. So it is taking time, but otherwise.
Okay, now the
Sir,
question
if I
is
can answer that
what
question.
the RP will do in these 2 years.
Sir, if I can answer that question.
Please, sir.
Sir, if you even put one brick, then effectively you are altering the status quo basis which the resolution plan has been filed for approval.
Okay, RA is agreeing to it.
Sir, even if the RA is agreeing to it, that does not mean that NCLT will agree to it. See, once you have filed the resolution plan for approval, it is custodial legis of the NCLT. It is no longer remaining in the domain of COC. There were certain assets. COC has already made up its mind and now is waiting for the adjudicating authority to say yes or no to it. Now, when the adjudicating authority is to take a decision, you cannot change the assets. Whether it's right, wrong, positive, negative, that's a different thing. But you are changing the premise for the adjudicating authority to have that decision. Now, if there is some damage taking place, you want to repair that damage, that's a different thing. But you cannot alter the assets when the adjudicating authority is to take one decision.
Okay, suppose it takes 3 years, 4 years, 5 years for approval in the NCLT. Then what is about the base of the IBC maximization of value of the assets?
That I'll answer. See, there is also a provision where we can go to the NCLAT and say that look, the status quo is getting altered by the decay by efflux of time. We can also go to writ jurisdiction to the local high court and say that look, the resolution plan will become infructuous due to the delay it is causing. But suo motu, if the home buyers are saying that you start construction, that we cannot do.
Very well, sir.
I also agree to what sir has said just now, because if you are having any kind of confusion, you can always seek guidance from NCLT, what is to be done. So even if your plan is under their consideration and the decision is not made so far, and if you are having some different proposal, you can again go to them, seek their guidance for that particular thing, and then you can proceed accordingly. But again, it is not under the authority of RP to proceed, even if he has the COC approval. That is perfectly discussed by all of you.
All right. Any other different view? No. Please proceed, ma'am.
There could be I think one more thing which can be added here, just like you said that the resolution applicant is also in favor of doing such thing, then in that case, revised plan can be asked from him. Then again, that will go for approval, and then the same can be given to NCLT. The earlier plan could be withdrawn, and that way can we proceed?
No, I don't think that will be a good thing.
And just thinking of an alternate, what to do?
When you say
Madam, I
yes,
will differ with you on that.
yes,
Because if I am an unsuccessful resolution applicant, if I am
Yes,
an
it will be open for all, sir. It will be open for all.
exactly,
Yes,
exactly.
you cannot give chance to just one. You will have to again open everything. So again, that is what I'm saying, that you have to seek the permission from NCLT that we want to open it for all again, because we have a different proposal now.
And that will open a separate can of worms. Handling that will be more difficult.
Yes, sir. Yes, sir. Altogether different. So obviously, when things are taking a lot of time, these are the normal issues which will come up. And in real estate projects, this is something very common. So any other question or any other point which we can discuss at this forum? May not be related to just interim finance. We can discuss anything which comes to your mind. We have, I think, half an hour more to go. And if you want to close, we can wrap it up, as you say. So mostly, can I have the locations? Can I know from where you people are?
yes, ma'am, I'm Shyam Arora. I am in Delhi.
Okay, so what is the scenario there, sir? So I'll be just quickly taking some.
Come again?
Want to know from you. What is the scenario of IBC there, sir? How is it in Delhi?
It is same everywhere.
Okay, so you have handled how many projects, sir, so far?
Basically, I am handling 4 real estate projects and 2 liquidation projects, 2 liquidation assignments.
Okay, that's so great, sir. So major challenges which you have faced so far, sir?
And in all the cases, I have filed my plan with the NCLT and waiting for the approval.
Okay. Yeah, we can hear from others also.
I'm Harvinder from Chandigarh. So as Mr. Arora said, the same is the scenario. Most of the things are, it takes time in the, adjudicating authorities or High Court, or there it takes. Otherwise, as far as the RPs or liquidator, they are, they do the things in the time bound manner, and even IPAs are also there to have a monitoring
Then
on.
something has to be done, Ravinderji. Something has to be done as far as AA is concerned. We have submitted a plan in September 2019.
Sir,
And
even
still to be approved by the AA.
Sir, even the government tried and made many things. They have given the timelines, but the judiciary, they have made it as a directory and not mandatory. So it is I don't know what is the solution and who can rein the delays.
That is the, I think, main issue which should be taken up at any forum, because this is the normal thing which I'm hearing from everyone. And obviously, in a real scenario also, we are facing such issues that if everything is done, if government wants.
I think the judiciary has to take it a call that okay, any application, be it IA or it's a CA, they should have at least their own timeline that it will be disposed of within 6 months, within 90 days, within 9 months. There is no timeline. You never know. It is years together. No,
we have very less number in NCLT. You know about Chandigarh bench.
I have
Both the
dealt a
benches are
case.
sitting for
It
half a day
started
only.
in 2018, and we are in 24. All matters are stuck up in the judiciary.
Yes, yes.
The original purpose fades away that way. But still, we have to manage what can be done. I guess.
Right.
Yeah. So
Thank you so
tomorrow
much,
you have
ma'am.
a
It
very
was
good
very
session.
informative session. हम लोग close कर रहे हैं अभी.
हाँ जी, ठीक है sir. So
Thank you
tomorrow
so
you will
much,
be
ma'am.
having one more session with Madhusudan sir. He's a
Yes,
very
yes.
experienced faculty.
Okay, thank you,
All the
ma'am.
best for that. Thank you.
Thank you very much, ma'am, for taking out time and giving session and providing so much knowledge to the participants. Thank you very much, ma'am. Ma'am, please share your PPT's presentation.
Sure, I'll do that. Yeah.
Thank you, ma'am.
Thank you everyone. Thank you.